Keelin Darby joins us now. Keelin, thank you very much for being here today.
Thank you for having me.
So it's been 4 months now since your husband, William Ben Darby, was released from prison after his conviction was overturned. So what's life like right now? What's it been like?
Life is obviously a lot better having him home for the both of us. He's in a much safer spot, and he's home. He's not having to look over his shoulder or deal with the craziness that's going on inside the Department of Corrections. He's around friends and family and people that care about him, and most importantly, he's in freedom, which is where he should have been the whole time.
It's a special kind of uncomfortable for a police officer, even former police officer, to be incarcerated, isn't it?
Yeah, I mean, Ben was in protective custody, or what they called that, but some of the conversations that we had, he wasn't in a safe spot. He was tried multiple times by prisoners who don't qualify as protected. Protective custody inmates are supposed to be police officers, judges, people of just a different sect, not just your regular average Joe person.
So what do you mean by tried? What does that term mean in this reference?
They just try to get him to act wrongly, to get him hemmed up. You know, he had a good appeal in the court system, which obviously was overturned by all 5 judges. And if someone on the inside, another inmate, if they didn't have a good appeal and they knew they didn't have a good appeal, well, they're not going to want to see you have success. So they'll come after you in some way and try to get you to mess up so that your appeal gets messed up, and then you're stuck in there with them. Misery loves company. So he was tried a few times, but he was able to navigate that and work around that and have a successful outcome.
Let's talk about that overturned conviction. The murder conviction was overturned because the jury, at least part of it, the jury was not allowed to hear and wasn't instructed to consider that Ben's training when deciding what to do in that very tense moment back in 2018. You're a police officer yourself. Anyone who's in your position, you go through, there's a lot of tense moments and a lot of split decisions that have to be made. It's not like TV or movies, for example. So can anybody, I mean, can the members of the jury, without knowing that, could they have really made an unbiased decision, in your opinion?
I don't believe they could have, because they weren't properly instructed. During the trial, Ben was compared to as a normal citizen, which he's at the time he wasn't. He was a police officer. He worked for Huntsville Police Department, and like you had stated, as police officers, we go through training that the average citizen doesn't go through, and we're taught how to do our job as law enforcement officers, unlike the average citizen. So I don't think, and I honestly, they didn't make the correct decision because they weren't given all the information they were supposed to have.
That must have been incredibly frustrating for you and the family, and HPD obviously too, to watch that process play out, where all these precedents and all this training and all these witnesses were not allowed to be introduced in trial.
Yeah, his whole trial was very frustrating from the aspect, I wasn't allowed to be there with him. You know, we were coming out of COVID, and I had to watch it along with others in a room. I'm his wife. He's afforded a public trial, and he wasn't given that back in 2021. That's changed now, obviously, with the different things coming up with our new trial this December. But no, his original trial was not fair to him, and that's something that we're all given in the rights that we have as Americans.
So when you think about the justice system now as a whole, and what happened, the police and the DA usually work hand in hand. In this case, the DA is trying to put a police officer behind bars. And what are your feelings now toward the DA's office?
I don't really have, I don't have any dealings with Madison County District Attorney Rob Broussard or anyone in his office. I don't work for them. I don't work for Madison County. I don't agree with what they did, but I understand that they have a job to do, but you need to do it the right way. And I fully agree that they didn't do it as truthfully as they could have.
And we should know we're going to talk to Robert Broussard here
Yes.
later today.
Yes, sir.
To get their side of it here. So you have a new judge and a new trial date. You mentioned it's in December.
Mm-hmm.
What difference do you think that's going to make?
Well, we have a new judge, and they are aware of what's happened and what's going on. And I don't believe that the new judge is going to do anything like the prior judge did. I believe and hope that this judge allows certain evidence in that should have been allowed, knows what the difference is between hearsay, what hearsay is and what hearsay isn't, because that was an issue during the original trial, allowing witnesses to testify on good reason when during the original trial they were told they couldn't. And you have to allow witnesses, you have to allow the defense every opportunity to prove their innocence, and that wasn't given during Ben's original trial.
Can you get specific about what evidence was not admitted, and so folks at home understand?
Yeah.
And maybe why, or do you not know why this evidence was not admitted?
I don't know why. I have my own beliefs on that. But you know, there were several witnesses that weren't allowed to testify to Ben's training. A training instructor that Ben had who taught him action versus reaction, which is what all law enforcement is taught in the state of Alabama and nationwide, that concept, that wasn't allowed to be introduced. That instructor had a real life moment while he worked for Huntsville Police Department where he ended up getting shot in the face because he waited too long. That very could have well have happened to Ben or Officer Pegues or Officer Beckles during the incident back in 2018. Thank God it didn't. Those 3 officers went home that night. But that is important information that the jury needs to understand in how he was trained. Case law that police officers have to follow and get their parameters of how they act wasn't allowed to be heard by the jury. That was one of the things that the appellate court judges had as an issue with the original decision because they weren't properly instructed.
In other words, similar situations that police officers have been in the past have gone to trial, and here's what happened, and the jury was not allowed to hear any
Correct.
of that.
Right.
And it usually fell
In the police
in the
officer's
favors
favor.
of the officer, and the jury was not
Correct.
allowed to hear any
They
of
weren't
that.
allowed to hear that.
And did your attorneys give you any idea of why they were not allowed to present that? I mean, what did the judge?
The judge said it wasn't relevant. It didn't apply. Our attorneys fought hand over fist to get information into that trial and weren't allowed to. It was overturned every time and given back to the prosecution. Every time that we objected, our lawyers objected, it was denied. Every time the prosecution objected, it was sustained. Every time.
Every time.
Every time.
Do you feel comfortable offering your opinion as to why?
I don't really know why the judge did that.
Okay.
I don't know if she was uncomfortable with the case. I don't know if she just didn't know exactly what was going on. I know that was her first criminal law trial to deal with something out of Title 13. So I don't know if she was just uncomfortable with the situation and with it being a murder charge. I don't know.
So going back, the shooting happened in 2018. The trial didn't happen again until the spring of 2021. A lot happened in that time. COVID, you mentioned that. COVID happened and we had the summer of unrest in 2020.
Right.
Do you think any of those factors played into the decision, whether the
Absolutely.
decisions were made by the judge or the DA or the jury for that matter?
Absolutely.
And how so?
So with COVID, I think a lot of things were hidden because you could close the courtroom, you could not see things go on. During Ben's trial, the TV monitor was turned off several times, that the room that I was sitting in for us to watch the trial was cut off. That's a violation of his Sixth Amendment right to a public trial. And the judge would just turn it off during the middle of testimony during several witnesses. The screen had a witness on the stand. It was turned off for an unknown reason for several minutes, and by the time that the connection was remade, that person who was on the TV screen was no longer on the TV screen, and they were talking about something else in the trial. So we had missed all that time of whatever what was said, you know, during that trial time. I don't know, but you can't just do that.
And these are things that the Court of Criminal Appeals looked at and said, this isn't right, essentially.
Right. So when we filed our motion for retrial, and then that was denied by Judge Pate, we went on through the process to the Court of Criminal Appeals, and that was one of 33 reasons of why this case should have not gone the way it did.
Mm-hmm. Do you think, and it's hypothetical, obviously, but if your husband hadn't shown up that day,
Mm-hmm.
what do you? It's impossible to say, but in your opinion, what do you think the outcome might have been with this other officer trying to talk?
Yeah, I
talk
can't.
Mr. Parker off the ledge.
I can't say that what would happen for sure because I don't know. I don't think it would have turned out well for the officers. I can say that just based off of what I've seen from watching that video several times of the incident,
Mm-hmm.
the lack of control those two officers had on the scene.
These were veteran officers, though, right?
They were, but just because you're a veteran officer doesn't mean you are a better officer than a younger officer. Ben and I both had gone through an FBI officer survival school 6 months prior to Ben's incident, and in that training, we had a very similar situation to what happened that day of the shooting. And in that training scenario, it was correct to shoot. The instructor of that class came to testify and was not allowed to fully testify to that training. Why not? Why couldn't he say exactly what happened during that training?
And this, you mentioned this earlier, this training is not unique to Huntsville PD.
Correct.
This
Correct.
training
It's
is
nationwide.
across the board. Officers are trained how to handle a situation involving a deadly weapon, as it were.
Right. A reasonable police officer, when confronted with someone with a weapon, whether it's a handgun, a knife, a hammer, a baseball bat, you're not going to not have your personal weapon out. Your department-issued weapon, if you're a reasonable police officer, is going to be out of its holster and ready to use to defend yourself and the public if you need to do that. Case in point, February 4th of this year, HPD was involved in a shooting with a guy who had a gun to his head. There was several other things going on in that situation, but that guy ultimately had his gun. All 5 officers told him to put his weapon down. He didn't do it. He made a furtive movement towards those officers, and all 5 of them shot him. Very similar to Ben's case. The difference being there was one reasonable police officer at Ben's scene who understood the threat in front of them, and there was 5 at this incident in February. Those officers have been cleared, have not been charged, have not been put through what we've been put through in the last 5 years, and they shouldn't be because what they did was correct. But how can you go after Ben Darby but not go after them? And that's a question that I've had since I found out about that incident. What those officers did was according to their training that HPD hands out, as well as the nationwide standard. They came home that day because they stopped the threat to themselves and others around them. Ben did the same thing and spent almost 21 months in prison for it.
You mentioned you had to watch the trial from the other room, essentially, on a TV monitor. What do you think it's going to be like this time in the courtroom, having to watch him go through all this again?
It's going to be, we've already been told it's going to be in the biggest courtroom in Madison County, and it is going to be open to the public. So I will be right there with Ben, going through it with him. Obviously, not to the degree that he is, because he's going to be the one on the stand. But I think it'll be comforting to him to know he has people on his side in the room, that he has support in the room. Because last time there was none. It was the jury It was him and his attorneys, and then it was the prosecution.
Is there a message that you want to get out to folks who are going to have to watch all this happen again through the news media?
Yeah, this never should have happened. It's been 5 years. This needs to get over with and done with. Ben Darby needs to remain a free man because he did exactly as he was trained by Huntsville Police Department and the nationwide standard. We've been backed by the Fraternal Order of Police, which is the largest organization for police officers in the United States. We've been backed by several other nonprofits who are police-related and military-related, who see this as this is. We've been contacted personally. I've been contacted by judges and attorneys throughout the state of Alabama, rooting for Ben Darby for this to win. When we got the conviction overturned in March, those people called me. Hey, we're so happy for you. We're so happy that Ben's coming home. We can't wait for you guys to be over with this and for you guys to be able to move on with your life. He's an innocent man, and it's not how you feel about it should not dictate what happens to him. It's according to what the law says. And what the law says does not correlate with what happened to him when he was convicted of murder.
So, guilty or not guilty, walk us through what's next for you guys, looking ahead, way ahead.
We haven't allowed ourselves to do that. Looking ahead, we're looking to December 11th, that week, or the week after that, depending on how long this trial goes. And we really don't have a long calendar looking out after that, because we don't know what's going to happen. We know there's two possibilities, and we're praying that it's favorable for us this time. But we're not looking past that week. We are working hard to get to that week and prepare for that week and do what we can to make sure that we are successful and that he is exonerated of all charges.
I'm sure you felt confident going into the first trial.
Yes.
But do you feel more confident now going into the second trial, given what happened with the appellate court?
Yes. We did feel confident going into the first trial, and obviously it didn't go the way that we had planned. But going into this for a second time, a lot of things have changed. A lot of things are different compared to what they were during the first trial. We have a new judge. We're not under a COVID restriction. It's open to the public. The story has come out as to what really has happened and what happened that day, that the jury wasn't allowed to hear in court that week. I fought tirelessly for my husband, and I will continue to do so until this is rectified. And we are done with this process, and we can move on.
Keelin Darby, thank you for joining us. We appreciate it.
Thank you for having me.
All right.